custody battle, which, as this court knows, is prime breeding grounds for this sort of charge.
And what are you suggesting, that the mother's telling the 5-year-old to go there and make these lies up, that the daddy's sticking his fingers in his butt? Is that what you're telling me?
I have no idea whether the child said that.
I don't think a 5-year-old can make that kind of stuff up, counsel.
Judge, I'm not telling you the 5-year-old even made those allegations.
No,
I don't have
the mother
police
could make
reports,
those
so don't know whether,
allegations.
exactly, I don't know who exactly
We
has
don't know
told the
exactly
police
who
this.
told the police that. Does the state know exactly who testified at the hearing yesterday? Was it the
No,
child
sir.
itself, or was it
It says VICREQPROS. I'm assuming that's the victim request
Motion to
prosecution.
set bond denied today without prejudice. I will revisit this issue next week, put it back on the docket for Monday. I want to deal with it after I know more about what the little 5-year-old said, what the state's position is as to whether or not the child's being coerced. I want to know more about that.
Judge, I would just bring to the court's attention that this bond motion was filed in the normal course. It was sent to Ms. Stanley directly, who is the intake SAO on these types of cases.
Okay.
If there are no witnesses here today, Judge, then certainly the presumption can't be great that this is true. The state had noticed they could have brought witnesses here today if they chose to, and I'd ask the court to set a bond as he's entitled to one.
Without prejudice. I want to know about what the kid said yesterday at the hearing. Set it for Monday at 10 o'clock or soon thereafter, as we can get to it. This man's facing the rest of his life in prison with no rights of parole. And if he did that to his 5-year-old kid, he's not going anywhere. And if he didn't do it, then we need to make that determination real quick.
Thank you, Judge.
You're welcome. Mr. Chapman. It's a battery case where the public defender attorney has asked that you be released or lowering of your bonds. When you came into first presentment court, I said bond of $25,000. That's usually an indication of the prior record of a similar act or on probation. The probation office has now handed me a probation warrant that was recently issued by Judge Vogel. You were placed on probation October of 1997 for 2 counts of battery. You're facing 2 years in the county jail as to those probations. You were given a second chance on those probations March the 12th of 1998. After you were given that second chance in March, you received this additional charge in May. Judge Vogel said no bond on your probation warrant, and I guess the question needs to be determined whether or not the victim is the same victim that he's on probation for.
Yes.
It is the same victim?
Leslie Ort, Your Honor.
Leslie Ort?
Yes, sir.
O-R-T-S?
O-H-R-T.
O-H-R-T. Is she present here today?
Yes, Your Honor.
Ever come forward? Could you approach that microphone, please, miss? If you turn it around towards you, please. Thank you for being here. Listen to me a moment, please. I have no idea why you're here, but you do need to know what your rights are before you make any statements on the record. You have the right to remain silent. Everything you do and say here today could be used against you if you are ever prosecuted for any of the events that have taken place between you and Mr. Chapman. If for some reason you come here today and tell a story differently than what you have previously told law enforcement, or if you admit here today on the record you have lied or you exaggerated these facts, you will go to jail here today on the spot for false crime report. You will go to jail here today for contempt of court. And you could be charged with a felony case of perjury, where you could be facing 5 years in prison. Now, I have no reason to believe you're going to do any of these things, miss, but you do need to know the consequences of such actions. And due to the nature of the fact that there are severe consequences of these actions, you have certain rights. You do not have to talk to me here today. I've only asked you to voluntarily come up here. This is not a trial. We're still in the very preliminary stages of determining his guilt or innocence in all these problems. So you do not have to speak to me here today. But you do need to know the consequences of speaking here on the record. You have the right to seek the advice of an attorney first. If you have any concerns about what you said previously or what you're about to say here today, it might be advisable that you go seek the advice of an attorney first before you're asked any questions. Do you desire to speak to me here today?
Yes, sir.
Okay, raise your right hand. You swear to tell me the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Your name, please?
Leslie Ort.
Spell your last name.
O-H-R-T.
All right, Miss Ort, to make this a little easier, let me kind of direct where I'm heading, because frequently victims in these types of situations where a man who's on probation for 2 batteries on you plus gets another charge, frequently they come down here today because they want me to bury this man under the jail. And on the other side of the coin, the other extreme is they want me to let him out. So if I kind of know which side of that coin you're on, will be able to help me direct the questions. Is this a bury him under the jail situation, or you want him out?
I would like him released.
Not happening. All right, so let's just get that real straight right now. Why in God's name would you want someone out of jail who you have on probation for 2 prior acts of violence against you, and on this case he allegedly dropped you on your head?
Because under normal circumstances, he's a very gentle man.
How can you suggest it's not normal?
Like a split personality.
Well, so what are you gonna do to ensure that that's not gonna happen? He's been on probation since October.
He hadn't drank for 6 months since the last time he saw you here.
And so what makes you think there's any difference?
Because I believe he's given 99% of himself to his probation.
Judge, he's got another prior on her as well.
I know he has other priors. I mean, he's been in front of me so many times I remember him. I don't remember her independently, but I do remember him, and that's why I'm telling her right now I ain't letting him out of jail anytime soon. And I can tell you Judge Vogel isn't, because there's the warrant that she just signed yesterday, or the day before, setting no bond. And she wants to probably deal with him on his probation violation. So the only question what's going to happen to Gregory is how much jail time he's going to get. He's looking at 3 years. Were you injured?
No.
What led up to the events that caused you to argue into such a fashion that he allegedly picked you up and dropped you on your head?
I was drinking and he tried to get me to leave.
Leave where?
A bar. And I resisted him. And I slipped from his grasp. And I
So
believe
are
it
you
was
changing your story now?
I believe it was at least 50% my fault that I fell.
And why would you say that?
Because I was drinking.
How many witnesses observed all this?
I really don't know.
Well, obviously if you're in a public location there was more than just you, wasn't
We
there?
were outside.
You're outside?
Yes, sir.
Mr. State Attorney, do you have the police report where she reported to the state or to the law enforcement officers what took place that night?
No, sir, just the CRA, the information.
And that CRA says he picked her up and dropped her on her head. It doesn't say anything about you falling. It doesn't say anything about you doing anything to cause him to drop you on your head.
Your Honor, she also signed it. That's her signature there, I believe.
Miss, you better be real careful because you're real close to finding yourself going to jail today. I'm not going to do it because we don't have the full police report and the officers here, but if you're trying to back off of this story thinking you're going to help this man, you're going to find yourself in trouble. Now, if he didn't do what he's accused of, then maybe he deserves to be released and maybe you deserve to go to jail. But the point is, it's not happening today. You understand me?
Yes, sir.
All right, you're excused. Mr. Chapman, if you want to plead guilty to violation of your probation warrant, that 2 cases plus the new case of allegedly dropping this lady while you were tussling or arguing with her, you'll be sentenced to 90 days in the county jail, straight time. Your probations will be over. You won't have to report anymore, and then when you're done doing your 90 days, you and she can go about your lives as you choose fit. If you choose to plead not guilty, which is certainly your right, these matters will go back in front of Judge Vogel. She's holding you without bond, and then these matters out of Plain City will be all resolved at one hearing sometime in the future. And the worst you could get is 3 years. And I don't know what Judge Vogel will do. I don't know what this lady's going to say at the time of the trial, but it certainly would probably make a lot of difference as to what she actually says. So I'm telling you what I'll do today based on what I heard, but there's no guarantee that that offer is still on the table if you go back in front of Vogel. It could go up, it could go down.